Hi everybody, today we shall learn about general defenses in law of torts. These are the defenses available to the defendant to raise against the plaintiff in a civil suit. There are 6 types of defenses that a defendant can raise against a plaintiff in a case of tort. They are voluntary non-fit injuria, inevitable accident, act of God, necessity, mistake and private defense. Out of these voluntary non-fit injuria we have already learned. Today in this video we shall discuss about inevitable accident. Inevitable accident means unavoidable accident. If the defendant does not intend the consequences or the wrong, then it is called inevitable accident. That means if the injury or loss is due to unavoidable circumstances, then it is not a tort. What is inevitable accident? Unavoidable accident. That means if the injury or loss is due to unavoidable circumstances, then it is not a tort. For example, dust falling in the eyes of a driver and subsequent result in an accident, dashing with one another in a crowded area, all these are examples of inevitable accident. Essentials for the plea of inevitable accident include: the accident could not have been foreseen and prevented by the exercise of ordinary care and caution. Ordinary കെയറിലും കോഷനിലും ആക്സിഡൻറ്റ് മുമ്പേ തന്നെ കണ്ടറിഞ്ഞ് പ്രിവെൻറ്റ് ചെയ്യുവാൻ കഴിയാത്തതായിരിക്കണം. നമ്പർ 2, the person causing the harm, that is the defendant, must have taken reasonable care and caution, and there should not be negligence from the side of defendant. The defendant must not be negligent. Let's see the application. It is a defense in cases of negligence, assault and battery. So the plea of this inevitable accident is applicable in cases of negligence, assault and battery, and it is not a defense in cases of strict liability. Now comes the famous case law, nitroglycerine case. In this case, the defendants who were a firm of carriers had received a wooden case for being carried from one place to another. As the contents were leaking, they had to open it and see. When it was opened, the nitroglycerine in it exploded and the office was damaged. The plaintiff, who was the owner of the building, sued for damages. The defense of inevitable accident by the defendants was accepted and the plaintiff could not succeed in his action. The plaintiff could not succeed in his action. The plaintiff was the building owner and he could not succeed for damages. In this nitroglycerine case, defendants എന്നത് എ ഫേം ഓഫ് കാരിയേഴ്സ് ആയിരുന്നു. അവർക്ക് ഒരിക്കലും ഒരു വുഡൻ കേസ് ഒരു സ്ഥലത്ത് നിന്ന് മറ്റൊരു സ്ഥലത്തേക്ക് ക്യാരി ചെയ്യുവാൻ വേണ്ടിയിട്ട് ലഭിച്ചു. അവരുടെ ഓഫീസിൽ അത് വെച്ച് കഴിഞ്ഞപ്പോൾ കുറച്ച് കഴിയുമ്പോൾ അത് ലീക്കേജ് കണ്ടു. സോ ഈ പാഴ്സൽ ലീക്കേജ് ആവുന്ന കണ്ടു, ഈ വുഡൻ കേസ് ലീക്കേജ് ആവുന്ന കണ്ടിട്ട് ദേ ഹാഡ് ടു ഓപ്പൺ ഇറ്റ് ആൻഡ് സീ എന്താണെന്ന്. സോ വൈൽ ഓപ്പണിങ് അതിനുള്ളിൽ നൈട്രോഗ്ലിസറിൻ ആയിരുന്നു. ആ നൈട്രോഗ്ലിസറിൻ എക്സ്പ്ലോസീവാണ്. ഇറ്റ് എക്സ്പ്ലോഡഡ്. സോ ഹെവി ഡാമേജ് ഈ ഒരു ബിൽഡിങ്ങിനും ആ ഒരു ഓഫീസിനും സംഭവിച്ചു. ബിൽഡിംഗ് ഓണർ ഈ പറയുന്ന ഫേം ഓഫ് കാരിയേഴ്സിനെ sue ചെയ്തു for his damages, but they arose the plea of inevitable accident and the court accepted the defense of inevitable accident. So the plaintiff, building owner, could not claim his damages. In this nitroglycerine case, the defense of inevitable accident was accepted for the following 2 reasons. Number 1, the fact that the wooden case contained nitroglycerine was not made known to the carriers. Number 2, properties of nitroglycerine was also not generally known to the public. Wooden case le nitroglycerine aanu ennullathu ee firm of carriersne അറിയിച്ചിട്ടുണ്ടായിരുന്നില്ല. അതുപോലെ തന്നെ നൈട്രോഗ്ലിസറിൻ്റെ പ്രോപ്പർട്ടീസ് ഒരു പബ്ലിക്കിന് അറിയുകയുമില്ല. ഇതൊരു എക്സ്പ്ലോസീവ് ആണെന്നും എക്സ്പ്ലോഷൻ നടക്കുമെന്നും ഒന്നും ഒരു പബ്ലിക്കിന് അറിയുകയുമില്ല. സോ ബിക്കോസ് ഓഫ് ദീസ് ടു റീസൺസ് ദ ഡിഫൻസ് ഓഫ് ഇന്നെവിറ്റബിൾ ആക്സിഡൻറ്റ് വാസ് അക്സെപ്റ്റഡ് in this nitroglycerin case. Let us discuss 3 more case laws. First one, Holmes versus Mather. In this case, the defendant's horses got startled by the barking of a dog and started running. They knocked down the plaintiff. The defendant was not held liable under the defense of inevitable accident. Second case, Brown versus Kendall. In this case, the defendant accidentally hit the eye of the plaintiff when he was beating their dogs which were fighting. As it was an accident purely, the plaintiff could not recover damages. Now the third case, Furden versus Hardcourt Rivington. In this case, the defendant had left his dog inside his car which was parked on the street. The plaintiff was walking near the car. Then the dog barked and jumped, thereby smashing the glass window. A glass piece entered the plaintiff's eye and he claimed damages. He could not recover as it was purely an accident. So friends, in short, what is inevitable accident? Inevitable accident means unavoidable circumstances. That means if the injury or harm is due to unavoidable circumstances, then it is not a tort, it is a defense, provided the person causing the harm must have taken reasonable care and caution and must not be negligent. So whenever a question comes in inevitable accident, write down your points and write down the nitroglycerin case. I hope you all understood inevitable accident. See you all on my next video. Happy learning.